Hi, I'm Aishwarya. I'm a fellow at the Aishwarya Center.
Hi, my name's Mohit, and I'm a research assistant at the SS Center.
Today, we just wanted to talk a little bit about a series that we're working on at the center on non-personal data. Mohit's primarily driving the series, and so we thought we'd just have a conversation about it just so we can go through what it is that we want to explore through the series of papers. So just to start off, I think maybe you could just tell us about why we are looking at non-personal data specifically right now at all.
The immediate context for looking into non-personal data is that a committee has been set up by the Ministry of Electronics and Information Technology under the chairmanship of Chris Gopalakrishnan, who is a co-founder of Infosys. And the terms of reference of the committee ask it to look into a regulation or a legislation on non-personal data. In addition to that, the data framework, the data regulatory framework in India over the last few years have seen major developments, particularly with the Personal Data Protection Bill, which is now before a joint parliamentary committee.
Right. And so the government's also made some sort of statements that they want, or has indicated in some documents that they might be looking at regulating non-personal data in some context, right? And so, I guess more generally, what are the reasons that a government might want to look at this area at all in the first place?
Right, right. So while not too many government documents explicitly refer to the term non-personal data, but when talking about interacting with data or using data for the benefit of Indian customers, they do make references to how they would possibly approach it and the possible objectives for what this approach would entail.
Mm-hmm.
Documents include the TRI paper on privacy, security, and ownership, as
Mm-hmm.
well as the Economic Survey 2018-19, which actually made an emphatic case for the use of government data that is stored with government and ministries, because that is data of the people, by the people, for the people, which is
Right.
what they
Yeah.
said in the survey.
Right.
And most pertinently, the Sri Krishna Committee report itself refers to the concept of community data, and
Mm-hmm.
it talks about the need to protect people who have contributed to such community data.
Mm-hmm.
And also, it interestingly says that we need to come up with mechanisms to protect corporate data, which would, I believe, be non-personal data. So inferring from these references, we get an idea of the possible objectives that the government could be looking at to regulate non-personal data, which range from better delivery of services in a more targeted fashion, evidence-based policy making.
Mm-hmm.
We also look at things like data as an economic asset, where it's a driver for the growth of several of the biggest companies in the world today.
Right.
Um, Competition concerns also factor in, where you're looking to create a level playing field between bigger entities and smaller entities which are competing with each other in the same ecosystem. So these are some of the reasons that we can gather from the documents that the government has put out over the last 2-3 years now.
Right. And I mean, even just looking at the different scenarios that you've just outlined right now and the documents you've specified, it doesn't really seem like there's a specific, it doesn't really seem like non-personal data really means one thing. Because if you look at the Sri Krishna Committee report, that's in a community data context, the e-commerce policy in another context. So can you talk a little bit about what non-personal data is and generally how it's been looked at?
I think that's a very interesting question, because usually the way non-personal data is defined is that it is all data that is not personal data.
Right. Yeah.
Personal data being any data which can be used to identify an individual. So that sort of classification is what has regularly been pursued, but the definition of non-personal data perhaps has to be more nuanced than that, because of, as you've just said, of the different variations that could possibly exist between non-personal data. So you mentioned community data, you
Mm-hmm.
mentioned aggregated data. The terms of reference of the committee itself, of the Committee on Non-Personal Data, make
Mm-hmm.
mention of these terms. They also refer to things such as artificial intelligence data. So that just gives us an idea that a simple taxonomy where you're saying that this is personal data and everything else is non-personal data may not entirely be suitable for the purposes of regulation.
That's fair. And I think, again, when you think about non-personal data and the many contexts in which it can be used, depending on how exactly you decide to frame it. So broadly, what are the various areas in which regulation can apply in this space?
So while there are several areas, including trade relations between countries as well as national security, which will inform how non-personal data is regulated,
Mm-hmm.
we have chosen to focus on three primary areas which we feel and we believe, based on global context, are key to the regulation of non-personal data.
Right.
These are definition and privacy. Definition, the problems with that we've briefly spoken about just now, and
Right.
we'll shortly come to what are the problems that arise with privacy. The
Mm-hmm.
second theme is ownership and access. Questions of who owns the data, who has access to it, and for what purposes, who
Mm-hmm.
has the right to benefit, become important, especially in varying economic situations that exist in countries across the world. And finally, competition and innovation, because data driven markets have certain characteristics that make them prone to being dominated by certain incumbent players. So we look to explore what these barriers are, why it is so, and what could be possible ways that we can frame the ecosystem that the concerns of competition and innovation can be balanced.
Okay. So I think, like you said right now, also just even from the definition of non-personal data so far, which in the European Union is basically just that it's anything that's not personal data. It's obvious that
Right.
any kind of regulation on this kind of data will also necessarily have to be in consonance with whatever personal data regulations there are. So, are there any privacy implications of aggregated data, or is this just something that, like, once you remove, your personally identifiable information, then it just you don't have to meet the same threshold?
I mean, that's what a binary regulation of the two would make it seem like. But if you actually look at how data functions and how data sets are stored, it probably won't be like that.
Mm-hmm.
This is because most data exists in the form of mixed data sets, which
Right.
is where personal and non-personal information are mixed. So the EU approach to this is to simply say that, okay, if you can separate it into personal and non-personal, then it's fairly straightforward. You apply each relevant regulation to the particular bit. But if the data is contained in a manner that is inextricably linked, which is a term that has been used in the GDPR,
Mm-hmm.
but the jurisprudence on what this term means, what all it includes in terms of, does it actually have to be impossible to separate the two forms of data, or in a case where it is extremely expensive to separate the non-personal from the personal data, would that also qualify for being inextricably linked? So
Interesting.
how that comes to be defined is very important to how the interface between non-personal and personal data will be treated. And coming back to your question on privacy, there are definitely concerns with regards to privacy. These stem not from the fact that the data initially contains personal or identifiable information.
Mm-hmm.
It's that when linked to other databases which are present in the public domain, you can gather information that is personal in nature. And that risk exists because anonymization, which
Mm-hmm.
basically means removing all personal identifiers from a data set, as of now is not an irreversible process. That basically means if there is a data set and you put it out there and it
Mm-hmm.
is linked to other data sets, you will be able to get some personal information. So it'll be interesting to see how the Data Protection Authority, which is envisioned under the Personal Data Protection Bill, deals with the question of anonymization, whether it treats it as it has right now as an irreversible standard in the Act,
Right.
or we accept that there will be certain inherent risks involved in any anonymization process and we look to safeguard against those.
Right. Yeah. And like you said, that's something that the Act will have to specify. Data protection regulation does is to restrict access to the information that's yours and the information that you produce. So how does this
Right.
translate to a non-personal data context, especially because a lot of the information that companies collect, for example, or that can be collected when you're wandering outside on the street and a CCTV camera picks you up. So there is a certain role that consent plays, but also that there are certain limits to it. So how would ownership
Absolutely.
fall in this context?
So as you said, there are a couple of issues right there with how non-personal data is different from personal data, in that there is the absence of an identifiable individual who
Mm-hmm.
will give consent and who will hold authorities accountable, etc. Um, Coming to what protections are currently available for non-personal data, there are protections available under copyright as well as under contract. So under copyright, the protection is in the form of a protection to data sets, which are
Right.
recognized under the Copyright Act. An amendment was brought in wherein the definition of a data set in a computer program was included in
Mm-hmm.
the definition of a work.
Mm-hmm.
And however, the protection doesn't extend to each and every data set. it extends to data sets which fulfill the requirement of creativity and originality,
Right.
either in the form or manner that they're put together or the way the information is presented. And Indian courts have tended to adopt the sweat of the brow theory, which is where they look at the effort and the investment that has gone into a particular data set to
Right.
determine whether it actually qualifies for copyright protection. And another form of limiting the flow of data and sort of defining who owns it, so to say, is contractually, which is where firms or individuals may enter into contracts limiting the kind of data that they share with each other, or
Mm-hmm.
into exclusive agreements where they share certain kinds of data only with each other. So, in the current legal framework, those two would be the options that are there.
So, I mean, so if we put what you just said into an example, so I'm assuming that just based on considering we don't really have a data protection act yet, one contractual way would be, so if you were to aggregate data, if from a ride sharing company, for example, then the company would need your consent to collect it in the first place, but then they could create a data set to infer whatever it is that they want to measure from a collection of people, and that can be anonymized, and that's something that they can then claim IP over if there's enough originality and sweat of the brow.
Right. So that also takes us to an interesting question, and it's actually a debate which is going on in several countries: is whether copyright protection should be extended to data sets that are generated as a result of computer authorship or they are machine
Right.
generated.
Okay.
So, assuming in this example, if the Uber, if simply the app is relaying certain data to the Uber servers on which they're relying to trace certain travel patterns after anonymization,
Right.
etc. Now, even if the database is creative and original, does it fulfill the requirement of having a human author? And the
Right.
necessity of
Okay.
a human author is something which now various jurisdictions are considering. As far as I know, the UK is probably one of the few countries which explicitly recognizes such kind of works and extends copyright protection to them.
Mm-hmm.
But there are other countries where this consideration, where this proposal is also being considered. And with regards to contracts, we have to understand that it is not in it is the way the ecosystem is currently geared is not shaped in a way that it incentivizes bigger firms to share
Mm-hmm.
their data. So
Right.
when we're talking about ownership, we also have to balance it with access, and we have to sort of see what are the incentives that can be granted to firms, or how can we make it a more harmonious relationship between all players in the ecosystem as far as data sharing is concerned.
Yeah, and I think that brings me to my third question, which I want to ask you about, which is basically the tie-in with competition, because essentially the government is looking at this as a way to sort of level the playing field and increase competition and potentially innovation. But so, I mean, it also does seem that not all data is equal, and so like even if you were to incentivize or mandate data sharing in some contexts, it could have unintended consequences to some extent depending on how exactly this is framed. So is there like a certain balancing act that needs to be done between sort of creating incentives to share data but also making sure you protect the data that is generated?
Right, right. I think there is definitely a balancing act between competition and innovation. So, to explain why that is, I'll briefly go into what the competition concerns,
Mm-hmm.
particularly with a data ecosystem or with a data-driven economy, are.
Right.
And these are that the market, the any kind of data-driven economy is geared towards favoring certain incumbents or certain dominant players in the particular market. This is because barriers to entry arise. Firstly,
Mm-hmm.
these barriers can be technical in the form of encryption standards or in the form of lack of interoperability of data sets. They
Mm-hmm.
can also be legal, as we just discussed, in the form of intellectual property rights or contracts, which confer certain protection and ownership to certain people over data sets. And
Mm-hmm.
finally, they can come as a result of network effects and economies of scope and scale. So, network effects refer to the fact that the more a service is used, the more its value increases. So, as more people search certain queries on Google, its ability to deliver better results increases. It's able to deliver these results faster.
Mm-hmm.
And as a result of that, it's able to attract more customers. So that is the first, that is what network effects are. And economies of scope and scale refer to the variety and the quantity of data that a firm possesses, because these allow its algorithms to be trained in a better manner,
Right.
again, to make the service delivery more efficient. So the idea is that all of these confer benefits on certain incumbents, which will need to be balanced so as to allow smaller entities to coexist. But at the same time, any regulation or any restrictions that the government puts in place on, say, mergers and acquisitions or abuse of dominant position must not be such that they disincentivize these firms from creating these data sets in the first place.
Right.
Because eventually, the price for that will have to be borne by the customer, who will then not get new products, not get better innovation, not get better invention. So the idea is definitely, as you said, to create a balance between the two. How that is a question that we look to answer in one of our forthcoming issues, where we explore various models that have been put forth, primarily theoretically at this point, on what can be the various constructs that you look at data sharing, whether you need to involve data fiduciaries, whether there can be a sui generis sort of right on non-personal data, which caters to its peculiarities. So these are things that we look to unwrap in further issues of this series.
Yeah, and maybe to some extent, even if data sharing is the way to go in terms of addressing competition concerns, because like you said, it's not like a small player is the same as an incumbent in the fact that they have larger processing capacity, a lot more money, obviously, and so it might not have the
Absolutely.
same level of security, encryption, etc. So it might not end up being as beneficial for the consumer as just it seems on the face of it. Um, so thanks so much for joining us. So we're going to explore a bunch of these topics that we just discussed over the course of this series, which we'll put out over the course of the next few months. The first one was already out. The introductory paper is out on the Aishwarya Center website. You'll find a link to it wherever you're watching this video or listening to us over your headphones. So thanks so much.
Thank you for joining us.